Green State University in Bowling Green, Ohio. So I'm a research scientist in life, and I'm not sure what the Jackson Center is relative to what I do full-time. I'm actually the McMaster Distinguished Professor of Photochemical Sciences at Bowling Green, and I use the word McMaster very selectively because Harold McMaster is a big donor to scientific things in our general area. But more importantly, for those of you who follow Wall Street Week, he was the man who 30 years ago thought about photovoltaic solar energy conversion, and out of that came the high-flying stock First Solar, which some of you probably have heard of, which is a major supplier of photovoltaics around the world. I want to take just a minute to introduce Greg Peterson, who's been really the power behind this Jackson Center activity from the day it began. But more than that, I want to tell you where this course came from and get your feedback on whether we should think about doing things like this again in the future. My wife is involved in the Symphony League of the Toledo Symphony, and at some conversations, Stefan Sonderling is the music director of the Toledo Symphony, just to make a little connection. And so at various symphony events, we've talked to several lawyers who come to Chautauqua on a more or less regular basis. And they mentioned, among other things, because they knew I was involved with the Jackson Center, that a course like this on Jackson, his legacy and times, might be of value to the many people who have legal and historical interests that come to Chautauqua. So with that as a little bit of a stimulus, we talked to Tom Becker and talked to others at Chautauqua Institution. And then Greg Peterson and I, with the help of our outside speakers, put together this course over the winter with Philip Slidell being gracious to provide the CLE credit for lawyers in the Chautauqua participating group. What we'd like to know is anything you might want to say. Well, maybe I shouldn't be so open. What we'd like to know is if you think this is a good idea and should we do something like it again. So that would be very, very valuable to pass to me or to Greg or to anybody that's associated with the Jackson Center if you have time. And then further, if you have time, take a trip to Jamestown and see what has grown out of nothing 7 years ago to a very distinguished, highly recognized center in honor of a Supreme Court justice, the only one in the United States. But I'll leave that to Greg to talk about in more detail. Greg Peterson is a lawyer in Jamestown with the firm Philip Slidell, and he claims that he became first interested in Robert Jackson seriously because of a speech by Sandra Day O'Connor at the dedication of a statue in front of a school on, Washington Street or something like that in Jamestown. And subsequent to that, discovered that the old Masonic Hall, or still maybe Masonic Hall, was falling in disrepair, and found some donors who could make contributions, and that started the Jackson Center. I got involved when I discovered in the Jamestown Post-Journal, when we were here right after September 11th, a day at the Jackson Center in which Whitney Harris, who was at Nuremberg, and Henry King, who was at Nuremberg, and Bernie Meltzer, who was at Nuremberg, were going to be interviewed. So I went down, and not knowing what I was going to find, and spent an entire 12 hours listening to stories from the Nuremberg trial. With that, I was hooked, and from there, we went forward. Greg Peterson got his undergraduate degree at Allegheny College, which isn't very far from here in the town of Meadville, Pennsylvania. Took his law degree at Dickinson College, which is in Carlisle, Pennsylvania, which is over there somewhere, and has been in Jamestown for the duration. Greg is a bundle of energy and makes connections all over the place. Thurgood Marshall's birthday was Greg's find, and so yesterday was Greg Peterson. You wouldn't know it from the Chautauqua presentation, but that was Greg's due. Robin Smith, who was at the Call of Christ yesterday, was Greg's find. When Robin came to the Jackson Center, she brought Dorothy Cotton with her, And so if you saw the movie yesterday afternoon, Walk in My Shoes, you'll know that that was a special event at the Jackson Center. So if you have any connections with anything, Nuremberg, Jackson, anything, just give one word to Greg and then watch. And in a few months, there will be a program at the Jackson Center on that particular activity. Greg and John Barrett will introduce the other speakers for the morning, and I don't want to take any more time, but just to thank Greg and for all the Jackson Center people. This has all been paid for by the Jackson Center, so this is the energy of the Jackson Center that's brought this to Chautauqua Institution. And I think we should thank the Jackson Center and those people involved in it for all the hard work that brought this activity to the institution. So Greg, now you can talk again.
Thank you. Glad I filmed that. Welcome again. This is our fourth day. We have one more day to go on this really unique and, as Doug mentioned, precedent-setting activity here at Chautauqua, where we've had an opportunity to take a course and to focus in on the man of Robert H. Jackson, his life and a time. And fittingly, tomorrow we'll be concluding with the biographer of Robert Jackson, John Barrett, who is off to my right. Today we have an opportunity to do a little bit of a unique program. You do not see E. Barrett Prettyman Jr. here. He's had an operation, in fact, Monday. But the good news, that which he was going to talk about, we did film. He did talk about the unpublished opinion of Justice Robert H. Jackson in Brown versus Board of Education. So we've put together an ensemble of speakers today to talk a little bit about what it might be like to be a law clerk for a justice of the Supreme Court, which Barrett Prettyman was. And so we've asked John and Steve so we're going to put together a program where you'll get to see the presentation that Barrett Prettyman gave 5 years ago. So we have a virtual Barrett Prettyman, and we have an ensemble built around that. So I'll turn the program over to Professor John Barrett. Just briefly, I'll get into much greater detail tomorrow, but John is from the St. John's University School of Law. He's an extremely distinguished writer. He has written much on Justice Robert H. Jackson. If you're interested in Jackson when the day is done, please give John your email, because you'll be put on an extraordinary listserv where you will be getting information on an ongoing basis about Jackson, his life and times and its currency. John was the editor of an extremely and a highly acclaimed book that you can get over to the bookstore. Maybe we'll bring some over tomorrow, entitled That Man, which was the unpublished manuscript of Robert Jackson. Oh, there we go. Unpublished manuscript of Robert Jackson, which John found, edited. It got all kinds of award and acclaim, and so, and there's more books to follow on Justice Jackson. And if John chooses, he can talk about that. But without any further ado, John Barrett.
Thank you, Greg, and everyone who was part of putting this together. I've been coming to Chautauqua now since 2001, so this is my 7th summer, and I'm completely hooked on it. 8th summer. The gap we have is considerable. Barrett Prettyman, whose parents did not name him after me, is one of our most distinguished lawyers in this country, an acclaimed Supreme Court advocate, senior of-counsel attorney with Hogan and Hartson in Washington, and in his youth, someone who had the distinction of clerking for 3 different Supreme Court justices. He was with Robert Jackson for the 1953-1954 term that concluded with the decision in Brown versus Board of Education, and Jackson only had Prettyman as his law clerk during that year, so he worked very closely, one-on-one, with Justice Jackson. And Jackson thought he was just the cat's pajamas, and asked him, and that's a Jackson phrase, asked him to stay on for a 2nd year, and Barrett, of course, agreed. Unfortunately, Jackson, who had a serious heart attack during that 1st year, passed away in October at the start of that, what would have been that 2nd clerkship year, 54-55. And Jackson's closest friend on the court, Justice Felix Frankfurter, then absorbed Barrett Prettyman into his chambers from Jackson's death until March of 1955, when Jackson's successor, Justice John Marshall Harlan, was confirmed by the Senate. And then Justice Harlan hired Prettyman as his law clerk for the remaining months of that term. So over the course of 2 years, Barrett Prettyman clerked for these three really amazingly great in our history and in those particular years justices. Now, what's a law clerk? A law clerk is an at-the-elbow assistant to a judge, a justice, up in the different rungs of the court system. Many judges and justices have law clerks, and it's a personal staffing relationship that really proceeds as the judge wants to use this young assistant. They tend to be lawyers just out of law school. It's often a lawyer's first job. And at any court level, it's a special and really rare opportunity. I had 2 years as a judge to a federal appellate clerk, and I think of it as a job that was wasted on me when I was a kid. It was maybe the best job I'll ever have, and I think about it every day. At the Supreme Court level, you're breathing the most rarefied air that a law clerk can breathe. And pure coincidence allows me to turn to an old friend, Steve Marzin, who was a law clerk to Justice John Stevens during the 1985-1986 term of the court, for just a little bit of background on what this role is in general, and of course anything that Steve wants to tell us about his particular year in work with Justice Stevens. Steve is a graduate of the University of Pittsburgh and Harvard Law School, and clerked for Judge Malcolm Wilkie on the United States Court of Appeals in the District of Columbia before he spent his clerkship year with Justice Stevens, and he's a partner with Sherman and Sterling in Washington. So interrupting his vacation, Steve Marsden.
Thank you, and I don't have a lecturer, as you can tell I'm not even quite dressed for this because I am on vacation, but Barrett is a great friend. He doesn't go into the full details. We used to debate against each other in college, me for the University of Pittsburgh and he for Georgetown, and he does live up to the name. He would be appropriately called Prettyman. He had the most gorgeous blonde golden locks, which he now, probably to avoid embarrassing the rest of us, keeps his hair trimmed short so we aren't blinded by the light. But he is an old friend. It's great to see him, and thanks so much for Greg for basically speaking up and making the connections that you really can only make at Chautauqua by coming to this institution and seeing a lot of old friends who you may not have seen for many years, and get to come back together. John is right that most clerks, especially when they are lucky enough to get it selected by a Supreme Court justice, believe they're breathing rarefied air, and if they have any egos at all, as most of them have, they swell it enormously. I'm reminded of what the reporter of decisions when I was clerking, a gentleman by the name of Henry Lind, said of clerks. The reporter of the decision is the one who writes the italicized syllabus. So if you ever go to the Supreme Court web page, if you just Google Supreme Court United States, you'll get directly to the Supreme Court web page, and has a wealth of information, including the calendar with all the sittings if you want to hear an oral argument. Also has all the opinions in PDF format. But there's a lovely opinion if, for example, you don't want to read or don't have the time to read the 134 pages on the Boumediene decision, or the equally dozens of pages on Medellin, some of these large decisions on Guantanamo Bay or the Consular Treaty. And he remarked to me that, and I guess it was a compliment, that I was one of the few clerks who realized that I was in fact a clerk. And clerks basically are at the service of their justice. They basically do anything the justice asks. Most of what they do falls into reading cert petitions, petitions for review in the Supreme Court, and helping in the writing of opinions. Sometimes they'll also write speeches or organize other events for the justice, but principally it's cert petitions and opinion writing. And on opinion writing, it runs the gamut of what a clerk might do. Justice Scalia, for example, if you pick up any of his opinions from the webpage, you can instantly tell, even if the name of the justice is erased, that it's a Justice Scalia opinion. He has a very distinct writing style. Why? Because he assigns his clerks to prepare a first draft of whatever opinion. is assigned by the Chief Justice or the Senior Justice in the majority to him. The draft will come in on his desk, and at least in the early days, also a cart with every book or other authority, other than a Supreme Court opinion, because he's got a set of that in his office, with every book or other authority on the cart with a bookmark in it to the page that's cited, because he will actually do his own work. And he'll go through the opinion, he'll rewrite it, he'll read every authority. It's really his opinion at the end. At the other, I guess this may be a similar point, Justice Stevens, for whom I clerk, took over from William O. Douglas. Douglas had a very different way of working with his clerks. He wrote his opinion from scratch and left blanks for citations. Now, it caused a problem, as I understand, if there wasn't actually any authority to fill in at the end of the sentences. But that did not stop Justice Douglas, and that's the way the opinions came down. Judge Friendly, he wrote all of his opinions on yellow legal paper and then gave it to his clerk to work on. For me, with Justice Stevens, he had the exact opposite approach. He would actually dictate the first draft of the opinion himself. There were parts that you understood very soon after working with him that you could not touch and edit, regardless of what improvements you thought you might bring to the opinion. And then there was a part, usually more or less in the middle, where you would do your work. Justice Stevens had a couple of clerks, so we got to work very closely with him. He now has 4, and you work just very closely with the justice in getting those opinions out. And again, I don't have a lecture. If anyone has questions about how the clerks work or how they're affecting your lives as because of their role in the law that comes down and affects us all, please feel free to ask. Yes?
How does one get chosen to become?
It's very helpful to have decent grades in law school and to work for what's called a feeder judge. Certain judges have very good relationships with the various justices, and that helps. But basically, they're like letters of recommendation. There are a couple of hundred unsolicited applications that come to chambers, and Justice Stevens used to. One of our subsidiary duties was to screen applications, and we'd go through and we'd pick the most promising, and the justice would review those himself. But it certainly helped to have a recommendation from a prominent judge, a prominent law professor, and very good grades. Yes, ma'am.
You have a friend who argued on an abortion case from the Supreme Court. She won't. But what she said was the argument before the court didn't really matter because everything was decided before the actual arguments in the court. Is that true?
If I can give a slightly nuanced answer to that, I've only had 6 arguments before the court myself. I think on some cases, and I think it's true with probably the abortion cases, the justices would have well considered the authority in the prior cases and precedents in that area and their own views, and it's probably very difficult or only at the margins that you could have an effect on a justice's opinion on an abortion case, for example, separation of powers cases. So I think that's true. I think it's an overstatement to say that in every case that comes before the court that it's prejudged or the justices are set in their ways before the advocates argue. What I think a lot of people don't realize is of the 60 to 70 cases that come before the court each year, there are only a handful of cases that really grace the front pages of the New York Times or the Washington Post. The primary selection method for getting cases before the court is whether there's a split in the circuits. Most of those cases are statutory cases that are only barely interesting to the vast majority of people, sometimes even to the advocates before it, because they're very minor issues of textual construction. So on those issues, I think it's fair to say that you can have an enormous impact on the court, and good or bad advocacy can determine which way the court decides. I'm reminded of that in one particular example, and it relates to something we've read in the papers these past days. I don't know how many people saw, I think it was in the front page yesterday, about the mistake that was made in Justice Kennedy's opinion in the child rape case. Well, at the end of the term, needless to say, there's an enormous amount of work that needs to be done. The clerks by that point are very knowledgeable about the court's docket. They're at the peak of their efficiency, but nonetheless, there's an overwhelming amount of work to get done, and it's actually less now than it used to be because the court handles 60 to 70 opinions per term now. When I was clerking for the justice, the court had on its docket it's basically a full capacity of about 150 cases a year. So the end of court press was overwhelming, and the way these cases get decided is in there's a vote taken right after the oral argument is heard. Every justice says how he wants to come out and why in more or less detail. The senior justice in the majority, which is usually the Chief Justice if he's in the majority, or now my old boss, Justice Stevens, will assign the opinion to another justice in the majority. Well, that opinion is then drafted and circulated, and what it then elicits is typically a number of one-line, please join me letters. And literally that's what they say. They say, you know, dear Justice Stevens, please join me, Harry Blackman, or whomever. Sometimes the opinions at the end of the term will not be of the same quality that prior opinions were. And I'm particularly reminded that one opinion on a trivial issue of statutory construction of the 1928 Flood Control Act came out, and the majority opinion really was wrong. And it was one of these instances where Justice Stevens, being a brilliant person, said that, you know, the definition of damage in 1928 is not how it is in the majority opinion, which seems to equate it with the word damages. Damages means damages to personal injury as well as property damage. And damage in the singular, though, really means only property damage. So I checked these 1928 dictionaries, and sure enough, he's right. The definitions are very clear. They say damage means this, and then the same definition, damages, means something else. And he writes a dissent, but the opinion comes out, there are already 6 joins, so instead of an 8-1, it turns out to be a 6-3 or a 5-4, and it's only many years later that mistaken statutory construction is actually corrected and the court flips. So there's a lot of impact an advocate can have on a case, in many of the cases, but not in the sort of cases that a justice would have thought about well and deeply.
I heard one federal judge say that oral argument changes the view of the case 1/3 of the time. Is his tentative vote changed based on oral argument? And I've seen change happen due to oral argument. I think it's important.
I agree. And it's also interesting for those who do oral argument, no matter how well you put things together in your briefs, and no matter how much you try to make your reply brief sort of encapsulate the important things and do what you would do at oral argument, it's never the same as the epiphany you usually have shortly before you, or during the time you're preparing for your oral argument and when you get up and speak to a court. Yes? Sure. The question was, do you get a chance to know some of the other justices and who were some of the personalities during my term, which is the term I clerked, which is the last term of the Berger Court. Since each chambers had at least 2, in just the case of Justice Stevens, or typically 4 law clerks, there's an unfortunate tendency for the chambers to function as 9 little law firms, and there's not as much interaction among the justices as you might think. In order to promote interaction with the law clerks, we had and I don't know who created it, but it was a great idea, a Take a Justice to Lunch program. So we would you'd have a group from 8 chambers, or we would usually get together with one of the other chambers since there was only two of us, and we'd take a justice to lunch. And they were all really wonderful people. Frankly, one of the larger personalities was the late Chief Justice Rehnquist, who was very funny, very free to dispense advice, and a really nice guy. He sticks out in my mind. But yes, there was that opportunity, but it was very limited. And sometimes with the more talkative or friendly justices, you'd see them in the Supreme Court building off hours, like Justice Powell, for example, was very courtly, and he would chat with you if he happened to see you walking around, early in the morning or late at night, and would usually have something very nice to say about how you're working too hard and you should take a little more time off. But so yes, ma'am. Well, particular cases will have particular issues, so that even if a justice, for example, like say, to pick a justice who's no longer on the court, Justice O'Connor, for example, was very clear that, and she had her own particular view of, Roe versus Wade and the abortion issue, and her view was not the same as Harry Blackmun's. She had her undue burden standard, and that was her view. And I don't think it would have been effective or realistic for an advocate to expect to talk her out of her undue burden standard. But that developed over time after her confirmation hearing, and it's still the case that in any individual abortion restriction that came to the court, there'd have to be an argument made and a determination by her whether that particular restriction was an undue burden. So I don't mean to suggest, and certainly I don't believe is the case, that issues are predetermined. However, I do mean to say that, especially for a justice who's been on the court for a while, they will have their own views. And one difference, and this may contrast with the recent Roberts and Alito hearings, many of the issues about which folks care most about and make it to the papers aren't the typical fare of lawyers in private practice or on the intermediate federal appellate courts. So, like the gun control restrictions case, Heller, I mean, that came up to the DC Circuit. I don't remember whether there was a conflict or not. Maybe there was with an 8th Circuit case. But, the last time the Supreme Court dealt with that is 1939 in the Miller case. I mean, those cases just aren't that frequent. So I think it's probably fair to say that for many of the issues, the justices haven't formed definite and firm convictions on something. But I think if the question were phrased differently at a confirmation hearing, if you asked them whether they were tabula rasas or blank slates, I don't think they would say that either. Oral argument matters. It matters more in cases they have had no prior experience or thinking with. Like I remember one case on whether individuals could file for Chapter 11 reorganization. I think there'd been one circuit court decision in the entire history of the bankruptcy code. They were pretty much blank slates on that one. But on other things, they've dealt with them before, and as you'd expect intelligent people, they will have thought and hopefully thought deeply about it before they get up there to hear the advocates. Yes?
Can you talk a little bit on the clerk's role in reviewing certain petitions, whether you summarize them or you make recommendations? And also, what kind of hours do you guys work?
Let me answer that, and then I'm sure I've taken way too much time.
We'll continue after the film.
Okay. Let me answer the second question quickly first. I am lucky, extraordinarily lucky, that I met my beautiful wife Louise during my intermediate federal court clerkship, because I doubt I'd be married now if we'd started going together when I clerked for Justice Stevens, because I don't think I've ever worked that hard. Basically, it was a 7-day-a-week job from whenever I could drag my sorry self up in the morning until when I fell asleep at night, because he had only 2 clerks. We were handling 150, or he was handling 150 cases a term, it meant from Monday through Friday we wrote opinions. We each had 10 or 11 majority opinions to write. He was concurring or dissenting in a third of the cases he wasn't writing the majority in. So we're an opinion writing machine. And then on the weekends is when we would deal with the more than 5,000 cert petitions that came in each year. So that was more than 100 a week. My co-clerk, Cliff Sloan, and I split them 50-50. So we read 50 cert petitions and dictated memos on 16 of them every weekend. And so we worked hard, and we were not in the cert pool, which we can talk about later. Maybe Professor Barrett wants to talk about. And so we would dictate memos for the justice so that he could make his vote at conference. And with that, let me leave it.
We have a festival of riches. Just to set the scene, this speech that Barrett Prettyman gave in 2003, I think, is the story of part of the deliberation process leading up to the May 1954 decision in Brown versus Board of Education. Brown was argued for the first time with its constellation of companion cases in December of 1952. The court then, at the end of that term, put the case over for re-argument and specified a number of questions on which it wanted additional briefing and argument. That re-argument occurred in December of 1953, and the decision occurred in May of 1954. During the second lap year, Justice Jackson began to scrawl first on a pad and then through typed drafts his thoughts and what was sort of moving towards a possible concurring opinion. A year earlier, the court had decided a major case, Youngstown Sheet and Tube versus Sawyer, the steel seizure cases, in which most of the justices had written their own opinions. And in this Brown deliberation process, second oral argument year, Jackson thought that Brown was going to be another of those cases where everyone wrote. Ultimately, this is not an unpublished opinion in Brown versus Board of Education. This is a think piece and a draft that at a point when Earl Warren is confirmed, becomes the chief and begins to marshal a unanimous court behind one opinion, goes into a file. But along the way, it's a very interesting story, and it turns out that it's an approach that's somewhat different than where the Warren unanimous court approach is, and it turns out to be a process in which Barrett Prettyman, as a law clerk, had quite a substantial advisory role with Jackson. And so without further ado, the video and E. Barrett Prettyman, Jr.
I thought we would explore that tonight. I apologize in advance for such a serious after-dinner, after-drinks subject, but I do think it's important at this place and this time that we understand the Justice's mindset just prior to his death. Commentators, including the estimable Richard Kluger, have all referred to his unpublished opinion as a single document. In fact, the Justice began writing it as early as the end of 1953, and on 5 separate occasions thereafter rewrote and expanded the original draft. Let's put these drafts in context. The first oral argument, as John has said, in Brown took place in December 1952. I became the Justice's only law clerk in the early summer of 1953. In September, Chief Justice Vinson died, and 3 weeks later, Chief Justice Warren took a recess appointment. The second oral argument was on December 8th of that year, and Justice Jackson began writing the first draft of his own opinion, voting to rule school segregation unconstitutional the day before that second argument. What was his state of mind at that point? It's fair to say that he had little reason to believe that the confusion which had attended Brown during the Vincent years had dissipated. He assumed that most, if not all, of the justices would be writing their own opinions. He certainly believed that there would be dissents, and he was fearful that the majority would place blame for the past on everyone but the court itself. To continue the chronology, the Justice repeatedly made changes in his draft in January, February, and March of 1954. and then on March 15th, for the first time, gave to me for comment what turned out to be the final 23-page version. I wrote him a frank and very critical memorandum. I typed it myself, and I must confess that in my naivete, it never occurred to me that anyone would ever see it except the justice. My main problem was that the tone of his draft was so negative and even confrontational that I thought it would give voice to those who opposed the court's decision. Don't misunderstand me. He was not negative toward the result being reached, an overriding of Plessy versus Ferguson, but rather toward how he assumed the majority would frame its opinion. I'll come back to that in a moment. On March 30th, 1954, 2 weeks after his last draft, Jackson had a heart attack and was hospitalized. At this point, he had not shown his draft to any other justice. I was there in Doctors Hospital when the new Chief Justice brought Jackson a first draft of his own Brown opinion. I waited down the hall while the two talked, and after Warren left, I read the opinion. Justice Jackson, although disappointed that it did not rely on more law, seemed overwhelmingly relieved that it contained none of the attributes he had feared, and delighted that it was an opinion he could join. He had me type up a paragraph as a suggested addition, but the Chief Justice subsequently rejected it for a very good reason. The paragraph could apply to segregation in general, and the Chief did not want even to intimate that segregation would be struck down in areas other than education. He was, you will recall, a consummate politician. At Jackson's suggestion, however, the Chief did add this sentence to the Brown opinion, quote, "Today, in contrast, many Negroes have achieved outstanding success in the arts and sciences as well as in the business and professional world," unquote. You will see in a moment how this harks back to Jackson's own drafts. The District of Columbia case worried Jackson probably more than any other justice on the court, because the Fifth Amendment applicable to the district did not contain an equal protection clause, as did the 14th Amendment applicable to the states. Justice Jackson persuaded the Chief Justice to insert the following sentence in the Bowling versus Sharp opinion governing the district, quote, "The equal protection of the laws is a more explicit safeguard of prohibited unfairness than due process of law, and therefore we do not imply that the two are interchangeable phrases." Justice Black, however, in turn persuaded the Chief to insert the word "always" in this sentence, so that it ultimately read, "We do not imply that the two are always interchangeable phrases." Justice Jackson was not happy about this one-word addition, since it implied that the two phrases were sometimes interchangeable. Now let us return to Jackson's own draft opinion in Brown to try to determine his views. The most important point, of course, is that he was prepared to vote with what he assumed would be a majority and strike down segregation in the schools as unconstitutional. He was drafting, in other words, a putative concurring opinion, although it sounded in part more like a dissent. What worried him the most was that the court would blame the South or the schools or the lower courts for segregation when they had all simply been following what the Supreme Court itself had explicitly ruled that they could do: segregate on the basis of race so long as facilities and opportunities were equal. He was also worried that the court would act by fiat without any legal basis whatever. Very near the beginning of his draft, he wrote, quote, "However sympathetic we may be with the resentments of those who are coerced into segregation, we cannot, in considering a recasting of society by judicial fiat, ignore the claims of those who are to be coerced out of it," unquote. And then he listed some of those claims. programs that many felt with sincerity and passion that their blood, lineage, and culture were worthy of protection, and that they had built their institutions on an almost universal understanding that segregation was not forbidden. He pointed out that many minorities practice segregation on a voluntary basis. The white South, he wrote, harbored a deep resentment against the program of Reconstruction and the deep humiliation of carpetbag government imposed by conquest. The problem thus involved more than mere racial prejudice. He was sure that it would retard acceptance of the court's decision if the northern majority, as he put it, adopted a needlessly ruthless decree. The court, he thought, should be forthright in acknowledging that the states with segregated schools had not, until the day of the Brown decision, been wrong to regard their practice as lawful. In fact, the predominant view for almost a century had been that the matter, at least in the absence of congressional action, was one left for solution by the states. And this view was reinforced by custom, which Jackson called a powerful lawmaker. You can see why, even though I understood the reasons for what he was saying, I was concerned that by showing sympathy for John W. Davis's argument, instead of placating the South, he might be encouraging it to defy the decision. Unlike the later Warren opinion for the court, which stated that evidence as to the intent of the framers was inconclusive, Jackson thought it quite clear that the framers had never intended, through the 14th Amendment, to outlaw segregation in the schools. His response, however, was that original intent was not controlling. Jackson, ever the practical man, thought it absurd to try to divine original intent as to events occurring many decades after the instrument was enacted. He felt that whatever had been the situation at that earlier time, Negroes had made such remarkable progress in such a relatively short time since the Civil War that discrimination based solely on race simply was no longer supportable. He wrote, quote, "Tested by the pace of history, the Negro's rise is one of the swiftest and most dramatic advances in the annals of man," unquote. In a multitude of cases, he wrote, the court, because of changing conditions, had struck down statutes once held constitutional. He concluded that what warranted the court's decision was a change in the Negro population. When first freed from bondage, Negroes had no opportunity to show their capacity for education or assimilation, so it was not unreasonable to teach them separately from pupils of more favored background. The practice over the years may even have been to their advantage. But, quote, "their progress under segregation has been spectacular," unquote. Whatever may have been true earlier, the fact that one was now in some degree colored simply could not afford a reasonable basis for classification. Education had changed too, no longer regarded as a privilege for the few. It was instead both a right and a duty, not purely a local matter, but one of national concern. The justice thought that the 14th Amendment gave Congress wide discretion to enact legislation dealing with segregation, binding on all the states. In light of limitations on courts' power to enforce their decrees, Congress could do a better job of supervision. He obviously hoped Congress would step into the breach. He was prescient when he wrote, to eradicate segregation by judicial action means 2 generations of litigation. The government had asked that the court remand to the lower courts with instructions to proceed with enforcement as rapidly as possible. Jackson responded, quote, "I will not be a party to this casting upon the lower courts a burden of contained litigation under circumstances which subject district judges to local pressures and provide them with no standards to justify their decisions to their neighbors whose opinions they must resist." Jackson favored going no further at the moment than entering an order that the constitutions and statutes providing for segregation were unconstitutional, and then ordering re-argument on the contents of any subsequent decree. In an earlier draft, Jackson made clear that he did not think it appropriate to outlaw segregation on the basis of several considerations then being urged on the court, including extra-legal criteria from sociological, psychological, or political sciences, and the extent to which segregation was offensive to contemporary opinion here and abroad. It wasn't that he disputed that segregation created an inferiority complex in Negro children, which retarded their education. He just didn't think such elusive factors such as these should be imported into the concept of equal protection. As for public opinion, he asked whether the whole judicial process would mean anything if the justices bowed to the will of those who had never read a brief, heard the oral arguments, or reviewed the historical research. Legislators, not judges, cater to public opinion. This section dealing with the social sciences and popular opinion did not appear in the final draft, probably because he just didn't think it was necessary. Thus, one may well ask why Jackson was so willing to join the Warren opinion when it differed in several material respects from his own views. The Warren opinion, for example, treated the history of the 14th Amendment as equivocal, whereas Jackson thought it quite clear that the framers did not intend to wipe out segregation. The Warren opinion relied in part on sociological studies that Jackson apparently thought were not a proper element of equal protection. And most importantly, Warren based his conclusion primarily on the harm that segregation did to Negro children, whereas Jackson based his on the disappearance over time of any claim that the two races were constitutionally unequal. I think the answer to why Jackson was willing to join Warren despite these differences is that Jackson liked the simplicity and directness of the Warren opinion. He thought even laymen could understand it, and as I have said, he was gratified that it did not place blame on anyone. Now remember, unanimity of the justices was not yet realistically expected. As a footnote, it's interesting that so much emphasis in the commentaries has been placed on the non-legal sources used by Warren, such as the social studies showing the adverse impact of segregation on Negro children. We who were there know that these studies were added almost as an afterthought and were not critical to the underlying thesis. Very little attention has been paid to other outside the record sources that the parties were not even aware of at the time, and that may have had more significance for both the opinion on the merits and the ultimate decree. Several groups of law clerks conducted studies outside the record. One of these was Alex Bickle's 63-page history of the 14th Amendment, and another was my own commentary on maps I had gathered showing the precise location in certain cities of Negro and white houses and schools. The memorandum I wrote in response to Jackson's draft opinion took issue with several of his points and with the draft's structure. Richard Kluger, in his splendid book, Simple Justice, gives me credit for Jackson's decision to write no more. But another contemporaneous memo I wrote indicates that Jackson fully intended to redo his draft, but was interrupted both by his illness and by Warren's opinion. In any event, as you all know, Jackson joined with the other 8 members of the court in the unanimous Brown decision. In an otherwise very fine article in the 1989 yearbook of the Supreme Court Historical Society, Jeffrey Hockett concludes that, quote, Jackson's argument for ending segregation was less susceptible to criticism than Warren's, unquote. While no one admired Justice Jackson more than I did, I have to disagree with this conclusion. The Justice's final unpublished draft opinion was well written, as one would expect, clear, lucid, and fully cognizant of all the problems attending a rational resolution of the cases. If anything, however, it was too forthright in light of the people it was trying to reach. Not only would it have been attacked, as Warren's was, but many of its points would have been used by segregationists to bolster their cause. This may have been one of those very, very rare occasions when it was to the nation's interest not to have Justice Jackson writing for the court, and I really think Robert H. Jackson would agree with that conclusion. Thank you very much.
And Prettyman was disagreeing with Hockett, and I think by far Prettyman has the better of that argument. What Brown is about is, of course, many, many, many things, including history and law and a judge's sense of proper behavior in that role. And each of those mattered enormously to Robert Jackson. He was a very serious lawyer. He was a lawman. And whatever his personal instincts and, frankly, the easiness with which he found segregation to be a deplorable thing didn't mean that there was an easy, satisfactory legal argument for him as a lawyer, much less that it was one that he felt would be appropriate for the court to use in its adjudicative role. And so it's those sort of three parts, the man, the lawyer, the judge, that I think are embodied in this reflective drafting process. The other thing I want to note, and it's obviously implicit in the story, and it corresponds to something that Steve was describing earlier, Robert Jackson was very much his own draftsman. Something like Justice Stevens dictating, something like Justice Scalia rewriting into his own voice any draft. But literally, like Henry Friendly and others, Jackson would begin with that yellow pad. And he sort of thought with his pen. And what's interesting about this one is that you really do have layers of drafts that allow you to sort of see the thinking process and the argument and the feedback. And the role of the law clerk. I mean, Barrett Prettyman calls Kluger's book brilliant. He doesn't quite quote the line out of a little modesty, but Kluger refers to Prettyman's memo back to Jackson as perhaps the most brilliant piece of work that a law clerk has ever done in the history of the Supreme Court. I think that may be an exaggeration. Of course, it's a black box that Kluger is assessing, so who knows what else is in there. But Kluger's assuming that Prettyman talked Jackson out of this opinion, which would have given some fodder to segregationists. And I think that in the end that's probably not entirely right. Barrett Prettyman deserves a fair amount of credit for that, but Earl Warren deserves full credit for that. And it really is the Warren political leadership between March, when he's confirmed, and May, when the decision comes down, that writes a simple, clear layman's opinion that has a little bit of law in it, a sort of plain language commitment to the 14th Amendment and a wave of the hand at the Fifth Amendment in the companion case, and an absence of the blame, which to Jackson was a very important part of the construction. So that's what's going on. It is a very complex topic, and I wish we had a full day to really explore the many, many angles. But those are a couple of thoughts. I'd welcome questions, and I'd also ask Steve to help field them too.
Would you say that prejudice is not a legal issue?
Would I say that prejudice is not a legal issue?
In other words, what this decision did is it said that children have to be put in, you can no longer separate schools.
Right.
And I think what Justice Jackson, in his conservative way, was saying that you can't eradicate prejudice.
Right. The question is about the law's limited ability to change people's hearts. And that's something that Jackson was well aware of. Jackson lived in McLean, Virginia, where Steve lives. But in the 1950s, Virginia was a different place. And Jackson, it had the segregated public schools, and it had attitudes that, we would find deplorable, that were not at all embarrassing and were voiced very aggressively. Jackson's sort of social set and neighbors and his handyman and et cetera gave him lots of ideas of what was going on. His colleague Hugo Black, who by this point is one of his close friends, not quite where Frankfurter was, but nearly, is from deep Alabama. And Hugo Black was sharing with the court generally, but with Jackson particularly, the prediction of what Alabama was going to think. Now, that didn't cause Hugo Black to hesitate. He was first and always ready to strike down segregation. But it was going to have a very adverse backlash reaction from a part of the country. Everyone recognized that. You didn't need to sort of pour gasoline on that by blaming them. And I juxtapose the way Earl Warren wrote Brown with the way that Justice Kennedy wrote a case, Lawrence versus Texas, a few years ago, which is about the privacy rights of homosexuals in sexual conduct. That reverses a decision 17 years earlier, Bowers versus Hardwick, which Kennedy in the second case says was wrong the day it was decided. Well, how could that be? It was a Supreme Court decision, a majority of the justices, et cetera, et cetera. Jackson did not want any message to the South that Plessy was wrong the day it was decided, that you people have been evil since 1896, that segregation is your sin, not the court's sin. And that's part of what he's noodling about as he's working on this draft opinion.
I'm just curious, I've heard this argument a couple of times. Warren was not a judge, he was a politician. And some people argue that perhaps we need different types of people on the Supreme Court so we get that different view. You were talking about how simplistic this was. Was the simplistic writing positive? Was it maybe not a positive thing? Is the idea of having I don't want to say non-lawyers, I'm not sure if Warren was a lawyer.
Oh, he was very much a lawyer. He was a district attorney in Oakland, California, and then the attorney general of the state of California, and then governor. And right. The question is, Earl Warren was a politician. Of course, he was appointed chief as the sitting governor of California, and had almost been the presidential nominee, had been the vice presidential nominee running with Tom Dewey in 1948. Dewey beats Truman, was Earl Warren elected vice president. It was that close. And he thus brought a certain different background than a judge might bring. Today's court is a very different court than this Brown court. Today's court is 9 justices, each of whom served as a federal appellate court judge, in a couple of cases very briefly, but each of whom had that as a background. And that's a important, vital source of experience, but it's a narrow thing. This court, the Brown court, had Harold Burton, who'd been the mayor of Cleveland and a senator from Ohio before he became a justice. It had Sherman Minton, who was also a New Deal bureaucrat, and then a senator for one term, and then a circuit judge, and then a justice. They both happened to sit next to Harry Truman in the Senate, which is what led Truman to appoint them. Tom Clark had not been a lower court judge. Robert Jackson had not been a lower court judge. Felix Frankfurter had been only a law professor of a particularly potent and influential type. And so it was a mix of experiences. I'm somewhat taken with the argument that it's a good thing for the court to have a mix of backgrounds. But you could sort of make strong arguments on the other side too. It is a very legal and scholarship-oriented job and responsibility that justices have. I'm wondering what Steve's views are, because the Berger court that he saw had a little bit of mix compared to today's court, which is entirely appellate judges.
Not too much, but I always tend to agree with John that different experiences are vital. I haven't done enough of the scholarship to trace it, but certainly one of the comments that was made about the benefits of Sandra Day O'Connor serving on the court, one of them was that she was an intermediate state court, state appellate court judge, and was also a state legislature, and brought thinking about the importance of federalism. It was more than just a doctrine, and was more
mean, at least one, maybe there were more than one, was Thurgood Marshall who said that. And this is a form of a diversity argument, frankly. I mean, we used to sort of think about a Jewish seat and a Catholic seat. Now we have a Catholic majority. There are 2 Jews. Religion doesn't seem particularly salient as we think about who should be on the Supreme Court. We've never had more than one African American at a time. We've only had 2 in history. We've never had more than 2 women at a time. We've only currently got 1. What should be represented on the court is a very complex mix of questions. But I think mix is a concept that you want to have. And I'm kind of with Steve. There are always people who can do a lot of research and supply the law, but the justices might be able to supply things that the brightest young lawyers can't supply. Sir?
How did FDR find out about Jackson and why he appointed to the court?
Well, I've got a book I can recommend. But the question was, how did Jackson come to FDR's attention and why did he appoint him to the court? They met when they were nearly boys. They met in Albany in 1911 when Frank, as he was called, Roosevelt, was a first-term state senator, and Jackson was a law apprentice. Roosevelt was 28, Jackson was 18. And Jackson was introduced by the attorney who was his mentor, who was also the committee man here in Chautauqua County and was in Albany on Democratic business. So he took his boy Jackson with him and introduced him to all kinds of people, and it was just a handshake. And then Jackson, a couple years later, is a lawyer, and he has succeeded this fellow as the Democratic committee man. And Frank Roosevelt is now the Assistant Secretary of the Navy because unexpectedly, accidentally, a Democrat won a 3-way race for president. And so Jackson now at least has an acquaintance with somebody in Washington. And he's got political patronage business that needs to be done in Washington. So when he goes from Jamestown down to Washington to try and get his folks appointed to postmaster positions and things like that, the only person he knows is Franklin Roosevelt. So he sort of arrives at his office and Roosevelt helps him make appointments and things like that. And the relationship develops. There's wonderful correspondence through those Wilson years. Then Roosevelt, of course, gets polio in 1921 and leaves the political scene. During those next years, Jackson is growing in stature as a lawyer, locally, regionally, even nationally. When Roosevelt returns to politics running for governor in 1928 in New York, Jackson's part of Lawyers for Roosevelt and is a proxy speaker. He doesn't serve in Albany, but he is an appointed member of different gubernatorial commissions. He's part of the re-election in 1930. He's part of the campaign for president in 32. He holds out for a big job, and so he doesn't go to Washington in 33. He gets a big job in 34, and onward from there. I can go on at great length about this, but it's an acquaintance that becomes a very solid and deep personal friendship, and of course a working relationship up through the New Deal years. Jackson is Attorney General, and then Roosevelt puts him on the court in 1941. The book is called That Man, and it's Jackson's account of that relationship. Sir?
In our political process, there seems to be a lot of angst from each presidential election to the next, that the one who comes into office will pack the court with a person of his, or perhaps some of her ideology. But it seems to me, looking back, that most of the justices, when they get on the court, irrespective of their political ideology, become very independent and often vote in a way, in a decision, that would be opposite what you may have thought when they were up for confirmation. Has that been something you would agree with? And I'd like Steve to respond to that also.
Yeah, I think that may be stronger than I would put it. I'm not sure how many justices turn out to be 180 degrees off of the expectations. But justices outlive the appointing presidents, and the issues of tomorrow are always unimaginable to us today. So I think what you get is a fairly known quantity in the moment of appointment and even during the presidency and the era of the appointing president. But as the years go forward, the justice, of course, develops comfort and skill in the justice role, and the docket, the world, the issues are new, and what you then have is a sort of independent development by the justice as he or she deals with those questions. Jackson was part of a coterie of people appointed not to be the 9 old men who had been striking down the New Deal, who thought that the congressional powers under the Commerce Clause to legislate were very narrow and restricted, and that the Constitution was a laissez-faire document. And they judged that way, and they turned on the New Deal and upheld a whole raft of statutes. But the court stopped having much business in that area. It became a war court, so issues of power of the president during the war, and then it became a civil liberties court, and questions of judicial power and constitutional meaning in that area, it became a court dealing with race. And Franklin Roosevelt was not thinking of this when he was appointing justices to the court, beginning in 37 and up through the rest of his presidency. Steve? Oh, there's the hook, I think.
Yeah. This was a teaser. This was a bonus to have John and Steve. Thank you very much. And obviously, John will be here tomorrow to pick up on this. And speaking of pick up, if you have an opportunity, you should pick this up because it'll tell you an awful lot more about Justice Jackson. And he's an extraordinary speaker, and he's going to showcase that tomorrow at 9 o'clock. So without any further ado, the time has lapsed. And Doug?
One comment, complete your electronic mail addresses with Tracy's backwards as here. We will get you information about the Jackson Center appropriately. So if you just leave your email.
Thank you very much. We'll see you tomorrow.